Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back to Legally Speaking. I'm Melanie Fanada, and today I'm joined by criminal defense lawyer Virginia Delinska. And we'll be discussing something many of you may have been wondering about. If I had only 2 beers before being pulled over, can I still win my DUI case?
This is such an important topic because so many people think that having just 2 beers means they're safe from a DUI charge, but that's not as simple.
Let's start with the basics. If someone says, I wasn't drunk, I only had 2 beers, does that matter?
Not really. Drinking just 2 beers isn't a guaranteed defense. What matters is your blood alcohol concentration and whether or not you're impaired. You can be charged with 2 main offenses in Canada. It's the impaired driving, which means that your ability to operate a vehicle was compromised, even if your blood alcohol concentration was under the legal limit. And then we have the 80 and over charge, which means that your blood alcohol concentration exceeded 80 milligrams of alcohol per 100 milliliters of blood, regardless of whether you appeared impaired or not.
Okay, so can you maybe explain to us the difference between being impaired and being 80 and over?
Absolutely. So impaired driving is about how you're acting. It's your coordination, your judgment, reaction time. Are these affected? So, for example, an officer might notice slurred speech or a difficult time walking. Being 80 and over, on the other hand, it's all about the numbers. So if your breathalyzer tests show your blood alcohol concentration is above the legal limit, it doesn't matter if you seem fine, you're guilty of that offense.
I've heard about something called the Carter defense. What is that and does it still work?
So the Carter defense used to be a popular argument in DUI cases. It involved challenging the accuracy of the breathalyzer results by presenting evidence that your blood alcohol concentration at the time of driving was below the legal limit, even if the test showed otherwise. Unfortunately, the Carter defense is dead now. In 2008, amendments to the criminal code made breathalyzer readings essentially irrefutable unless you can prove that the machine malfunctioned or wasn't operated properly.
Okay, so let's talk about how alcohol affects people differently. Does it matter if someone is more or less experienced with drinking?
It can. A novice drinker might feel impaired after just 2 beers, while a more experienced drinker might have 3 beers and not show any obvious signs of impairment. However, blood alcohol concentration levels don't care about experience. It's a matter of science. So even if you don't feel drunk yourself, your blood alcohol concentration could still be over the limit.
So someone who has had 2 beers could still be charged with impaired driving or 18 over. Can you maybe share an example?
Definitely. So, one well known case involved a driver who claimed to have only had 2 drinks, but their blood alcohol concentration was well over 80. They were convicted because the breathalyzer showed a blood alcohol concentration above the legal limit, and there was their driving behavior, for example, like swerving, which ultimately supports impairment. So, even if they only had 2 beers, factors like body weight, metabolism, and the time frame of drinking can all impact the ultimate blood alcohol concentrations.
So, Virginia, if someone gets charged despite only having 2 beers, what defenses might work in their case?
So there's a few. So for example, charter violations, if the police didn't respect your rights to counsel or took too long to conduct the breath tests, the evidence could be excluded. There could be procedural errors. So if the officer didn't follow proper protocol, when administering the breathalyzer, the results of that breathalyzer might be inadmissible. And post-driving alcohol consumption, so if you drank after parking your car and before the test, that could explain the high blood alcohol concentration that wasn't present while driving.
So, what happens immediately if someone gets charged with a DUI?
So in Ontario, you're looking at a 90-day roadside license suspension, a 7-day vehicle impoundment, and a $550 penalty. So these consequences kick in before you're even convicted. And if convicted, penalties increase significantly, including fines, education programs, and potential jail time.
So, Virginia, can someone win their case if they were being pulled over after only having 2 beers?
So it's possible, but not guaranteed. You will need a strong legal defense tailored to your case. So the law doesn't care about how much you drank, it cares about the evidence. That's why it's crucial to have a lawyer who can analyze every aspect of your case and identify possible defenses.
Well, thank you so much, Virginia. This has been really informative. And to everyone watching, remember that it's not about how much you drank, it's about what the evidence shows.
Exactly. And if you're ever unsure, don't risk it. Call a cab, take a ride share, or have a designated driver. It's always better to be safe.
Well, thank you so much, everyone, for watching Legally Speaking. Don't forget to like, comment, and subscribe for more legal tips and insights. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.